Yeah.
Yeah. No, I don't know. Thank you.
Yes.
Mayor, we will do a few items, before we start. What's going on? 6:35. That's what it says. So we can't start it. Can't start it before the end. Yes. We'll get a few items out of the way. 6:35. I'm going to try.
Okay, good evening, everyone. We're going to start our meeting with the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The first item on tonight's agenda are the warrants and claims which have been audited. Do I have a motion to approve and authorize the village clerk treasurer to pay the warrants and claims? Thank you, trustee Santoro.
I'll second.
Thank you, trustee DiNatale. Trustee Walsh?
Yes.
Trustee Santoro? Yes. Trustee DiNatale?
Yes.
Trustee Galsecki?
Yes.
Mayor Minicone?
Yes.
The prior meeting minutes are before you for review and approval. Do I have a motion?
I make a motion.
Thank you, trustee Galsecki.
Second.
Thank you, trustee DiNatale. Trustee Walsh?
Yes.
Trustee Santoro? Abstain. Trustee DiNatale?
Yes.
Trustee Galsecki?
Yes.
Mayor Minicone?
Yes.
The next item is a resolution is needed to hire Evan Schreiberg as a lifeguard at $18.50 per hour and hire Carolyn Powers as a lifeguard at $17 per hour. Evan Schreiberg is returning and Carolyn Powers is new.
I'll make a motion.
Thank you, trustee Santoro.
I'll second.
Thank you, trustee Walsh. Trustee Walsh?
Yes.
Trustee Santoro? Yes. Trustee DiNatale?
Yes.
Trustee DiBartolomeo?
Abstain.
Trustee Galsecki?
Yes.
Mayor Minicone?
Yes.
The next item on the agenda is a resolution to hire Caitlin O'Brien, Elizabeth Hardy, and Douglas DiNatale as beach attendants, all at $16 per hour.
I'll make the motion.
Thank you, trustee Santoro.
Second.
Thank you, trustee Galsecki. Trustee Walsh?
Yes.
Trustee Santoro? Yes. Trustee DiNatale?
I abstain.
Trustee DiBartolomeo?
Yes.
Trustee Galsecki?
Yes.
Mayor Minicone?
Yes.
The next item is a resignation of Jonathan Badger from the planning board. Jonathan sent us a very nice letter explaining that he needs to resign from the planning board, and we would accept his resignation with regret.
I'll make a motion.
Thank you,
I
trustee
second.
Santoro. Thank you, trustee DiBartolomeo. Trustee Walsh?
Yes.
Trustee Santoro?
Yes.
Trustee DiNatale?
Yes.
Trustee DiBartolomeo?
Yes.
Trustee Galsecki?
Yes.
Mayor Minicone?
Yes.
You have before you proposals to repair a fence at West Harbor, so we need a resolution to approve the proposal from Williams Fence Company to remove and replace the 6-foot chain link fence along the ball field at West Harbor Beach for a total of $10,500. And Williams Fence was the low proposal out of the 3 proposals that we obtained.
Is that on the West Harbor Drive side?
No, that's between the rod and gun.
Oh, that one, okay.
Further east.
Yep.
Okay.
I make a motion.
Thank you, trustee DiBartolomeo.
I'll second.
Thank you, trustee Santoro. Trustee Walsh?
Yes.
Trustee Santoro?
Yes.
Trustee Nyberg?
Yes.
Trustee DiNatale?
Yes.
Trustee DiBartolomeo?
Yes.
Trustee Galsecki?
Yes.
Mayor Minicone?
Yes.
And then last item on the agenda for items to be handled this evening, other than public hearings, is a proposal from H2M So we need a resolution to accept the proposal from H2M Professional Engineering Services to perform the annual chemical bulk storage audit of village's 3 sodium hydroxide and caustic soda facilities located at plants number 1-1, 1-3, and 2-1. And the proposal is before you, and the amount of the proposal is $2,800, which is the same as last year's fee for H2M to perform this inspection.
I'll make a motion to accept the proposal.
Thank you, trustee Donatelli.
I'll second.
Thank you, trustee Nigro. Trustee Walsh?
Yes.
Trustee Santoro?
Yes.
Trustee Nigro?
Yes.
Trustee Donatelli?
Yes.
Trustee Bartolomeo?
Yes.
Trustee Dupkowski?
Yes.
Mayor Manning.
Yes.
The next item on the agenda would be the Pine Howard Park, Pine Howard Park, and Howard Road repair, but we have to reach 6:35.
Well, I have a few things, so it's 6:34, so let's start. I would like to congratulate our water department, our Bayville Water Department, for the second year in a row on the Long Island Water Commission's best tasting water. We appreciate all their hard work. We always knew it was the best. It's nice that they get recognized. We're going for the 3-peat next year, so we'll have a nice shiny trophy for another year.
That's great.
I got my weekly bridge update from Nassau County, and they are on track to be completely finished by June 11th, still June 11th. It'd be wonderful to have them all done. And they will be cleaning up the area afterwards, they said, and doing some plantings, et cetera. And we have on Monday, the American Legion is again hosting the Memorial Day Parade, which will start here at Village Hall at 1 p.m. So we hope to see everybody there.
It is now 6:35 p.m., so I can go ahead with the public hearing notice.
Okay.
Notice is hereby given that the Board of Trustees of the Incorporated Village of Bayville will hold a public hearing commencing at 6:35 p.m. on Monday, May 20th, 2024, in Village Hall, 34th School Street, Bayville, New York, 11709, to consider the matters summarized below. Effectuating an assessment, levy, and collection of 4 proportionate unpaid sums due against the house and property owners abutting Howard Road and Pine Park Avenue, all of which are non-Bruce streets, as proposed by Tim Wilson, and authorized representative for petitioners of Pine Howard Homeowners Association. By order of the Board of Trustees of the Village of Bayville, Maria Alfano, Party Village Clerk Treasurer. The notice is dated May 3rd. We have an affidavit of publication for this item. We have an affidavit of mailing for this item also. So I will turn the folder over to you, Mayor, and is Mr. Wilson present? Okay, very good. Would you come forward, Mr. Wilson?
How are you?
Good. Enjoying this warm weather.
There's no form, but they're posting for the record.
Okay.
You're welcome. Okay, Mr. Wilson. So you were here to tell us who your recalcitrant homeowners are.
Yes, so, we have 5. 3 of the 5 are actually recalcitrant type of, not really the right word, they just wanted the money taken out of their taxes. But, we have Angie Carbone from 2 Howard, Lois Nadler from 1 Howard, Kay Wimmers from 6 Howard, Tom Levy from 6 Pine Park, and Francis Beal from 5 Pine Park.
I'm not sure why I'm in that. I never said that I wouldn't pay, for maintenance of the road that needs to be done.
Excuse me, I'm sorry. Could you please come and
Okay,
identify
I'm
yourself
sorry,
for the
just
record?
don't
No
want
worries.
to be, just don't like to be accused of stuff.
I'm not accusing, there was no response.
Yes, gentlemen, your conversation needs to be directed to the mayor and
Understood,
board.
ma'am.
So, do you need to speak, Mr. Levy?
At some point, maybe.
Okay, so, Mr. Wilson, at this point, what I have for the record is an amount of $568.70 per homeowner that
Correct.
is listed as recalcitrant,
That's correct.
correct?
That's,
Okay. That will be the amount that would be assessed to each of the homeowners if the board goes ahead with the assessment.
That is correct.
Okay, and you already said Francis Field, 5 Pine Park, Tom Levy, 6 Pine Park, Kate Wimmers, 6 Howard, and Lois Nadler, 1 Howard.
And Angie Carbo to Howard.
Oh, okay,
Angie was the lady there.
okay,
She just wants the money taken out of her taxes.
no worries. Okay, very good. Mayor and board, do you have any questions for Mr. Wilson, or if you'd like to open it up to the
Yeah, I'll
floor?
open it up to the floor, yes.
Want me to step aside?
Sure, please.
Thank you.
I'll speak for Angie, who's,
Excuse me, Mrs. Nadler, I know who you are, but I need you to identify yourself for the record, please.
I'm Lois June King, I was a king before that. Nadler,
And your address?
1 Howard Road, Bayville, New York.
Thank you.
Now, I and Angie live across from each other. We are at the end of Howard Road. Angie can't come because of, I said she's 98, and so I'm gonna speak for her because I'm young. We never use Howard Road or Pine Park Road. And so we're being charged for something that we don't use. The idea of paying something to the village of Bayville is just fine, to keep our roads up, just fine. It's just, this is a screwy thing. I'd rather pay for the road that I use every single day and it's in that good condition than these roads that I don't use. I don't use Howard because I go this way and Howard goes that way, and I would be going towards Center Island. I never do, and Angie doesn't drive at all anymore. If we could be charged something for a road that is used by us, gladly give the money to Bayville.
Like you live on Howard and you're part of the Pine.
I know,
Park
it's by
Avenue
an
Pine Avenue
inch.
Association.
No, I'm not here to dispute it, to fight it, because that's not nice. It's too great a place. But, it's absurd, the use of the monies that way. I'm being charged for something I don't use, and she doesn't use. That's all I want to say, and whatever is decided, but just, I had to make the point of where we are. We're right at where the road ends. It's Sound Beach Road, you never remember it. I'm at the end of that. I'm at the house with the red Jeep in the driveway. You go right out of my driveway right out into Bayville Avenue. And that's all I want to say.
Is your address Howard Drive or Sound Beach?
Howard Road,
Howard, what's?
1 Howard Road.
Howard Road.
And she's 2 Howard Road.
So when you leave your home to go to Bayville Avenue, you don't use Sound Beach Road?
Yes, I do, sir.
You do.
I don't use Howard Road, and I don't use Pine what?
Pine
Park.
Road.
At the end of the day, you live on Howard Drive.
Road. And I'm not here opposition, no, that's wrong. I'm just saying, I'm on Social Security, so is Ann. It's a lot of money beside the village taxes. And it's just something, if you ask me, oh, would you give the same amount of money because of blah, blah, we're doing this, I think yes, you know. But it seems absurd not to voice my voice because of this. That's all.
As we should.
Yep,
Thank you.
thank you.
Anybody else like to speak?
Ah, yes.
Good evening. My name is Tom Levy. I'm at 6 Pine Park Avenue. I have no problem with paying my fair share of road maintenance and that kind of thing. I guess it's kind of 2 different projects with the apron out front wasn't done correctly 16 years ago. It wasn't graded correctly. Needs to be redone. It's all broken up.
Isn't that part of the project?
What's that?
Isn't that part of the project?
Yeah. That's what I'm saying. It needs to be done. I agree with that. Also, the grading needs to be done too, because when there were some illegal speed bumps that were put on the road, and it kind of beat it up a little bit more potholes and that kind of thing. Hopefully, they learned their lesson, because now Tim is, coming up. I have some pictures, but I won't bore you with those. It was how people were driving around Frank Beal's property and then going up towards Tim's, and then mine. Sometimes even driving in my front yard. But hopefully those speed bumps don't come back, but that's another issue. My point of that, and it goes back to the speed bumps, where they brought up the point where you own in front of your house to the middle of the road. That's your property, basically, and then it's an easement. Everybody does that, everybody shares that, you can't block it, blah, blah, blah. So that was brought up years ago, or last year, a couple of years ago, whenever. So the point that I'm making is there are two basic properties that are on corners. One is Billy Blier's, the other is Joe Letta's, where they have a significant amount of road front, probably 3-4 times of what the normal average homeowner has. I believe my property is 40 feet, and that's how most of them are, 38 and a half, 40. I measured it out a long time ago because I wanted this formula to be calculated in. So basically, how it would work is my property, I would pay the 40 feet. Now, if this is, let's say, Billy Blier's, where it goes up Pine Park and then comes down Howard, then that's about 120 feet. So it's very easy to calculate that, and obviously that's his property. He owns that property. I don't want to park there. I wouldn't want someone parking in front of my property if I had that piece, but they utilize that. Joletta actually doesn't even have a driveway, or he has a little shed, but you couldn't fit a car in there. So basically all of his parking, and he's the only exception, the only parking he has is on Howard and Pine Park Avenue. Now he can put 5-7 cars in there on between Howard and that. So that's what I'm saying is, if you calculate this out by linear footage, it's not going to change a lot. It might, take 40 bucks off of, some people that are struggling for money. But then the people who have that extra lineage, that extra road front, should pay their fair share. And it's basically two that would, between the Joletta and Billy Blier, they're probably the only two that would expand and increase their costs on this project. Now, obviously, you would have to just say the apron is X amount divided up between the houses. But then the other part of the project with the grading and the gravel that's put down, that should be calculated by the linear footage in front of your house, what you own. So that's basically my point.
Did you ever have this discussion with them before?
I've tried to, but I've been vilified, and it's just really hard to talk to them. Here I'm being accused of not wanting to pay. I'll pay. I have the money. Not short of money. My house needs a paint job, but doesn't mean I'm poor. Doesn't mean I'm destitute. So I'm just sick of the harassment, and make them pay their fair share. I think. I mean, there are two calculuses to do that. And to equate, if you go out to dinner with somebody and they have a Caesar salad and a nice tea, somebody else goes out and has appetizers, bone-in ribeye, martinis, dessert, a coffee after, and they want to split the check even? No, you should pay more. It's just a common sense thing. But it is what you own on your property. No one should be forced, she shouldn't be forced, I shouldn't be forced to pay for someone else's lineage of road work.
When you drive on the street by your house, you drive on the whole street, don't you? You don't just drive on part in front of your house. You use
pretty much. I go in, I'm the second left.
You're driving on somebody else's share of the road.
Yes.
So the fairest thing we devised is that everybody pays a portion of it. Because it's the road that needs to be improved, the whole road.
I understand that, but usage of that road, yes, people drive on it, but then you have, as a homeowner, you have the right to park in front of your road. So are you saying that I can park down near the block? On Billy Pliers? So are you saying that I can park down there?
No, I'm saying you don't drive, I'm not talking about driving, I'm not saying about parking. You brought up parking. You're not gonna drive on 40 feet of the road, you're gonna drive on the whole road. The whole road has to be.
Go to your house.
The whole,
Well, if you have a delivery person, they might stop at your house, but then they might go beyond your house and turn around. The road's being used by everybody.
and everybody's home will benefit from the fact that the road has been improved.
I understand that.
It's gonna go
Sure.
to the value of your house.
Sure, I'm not arguing that, I'm just saying that people need to pay for, they have extra usage for the frontage that they're using. They can park, they can use that roadway.
You have a
Mayor,
company
if I
that
may
comes
just
parks in front of your
clarify.
house?
The way the local law is written.
My company?
Company, to your house.
My company, but it's not like,
But they park in front of your house.
I don't park in front of somebody else's house. I mean, if it's an issue where, okay, it's even Steven and your point of, oh, everybody uses the road, well, does that mean I can use the road and then I can park down on Howard?
You're talking
Because if
about-
I can park down on Howard, I'll pay the extra $40,
Okay.
but then I'm gonna be a pain in the ass, parking down on Howard in front of their houses.
I get your point.
Thank you. Appreciate any consideration, I'm just, if you're talking $40, it's not a big swing, and they can afford it. Well, Joe Letta can afford it, and Billy Blair can afford it, and it's not a big deal. They should pay their fair share on the lineage. Yeah, everybody drives on the road, but they have extra usage of that road. It's their property. Why am I paying for their property?
Is there anybody else that would like to speak about this at this time?
I just start off by saying when I go out to dinner, I split the bill with everybody, so they just got, not just some salad, but that's just me. Tom does use the road down Howard. He parks his car there with his kayak constantly during the summertime, leaves it between, Stephen Lisa's house and the other house right on the beach, so he can easily.
I offload my kayak and that's it.
Okay.
One of
I
the-
drive down, offload it and leave. But that's a common area. That's the common area. You're being disingenuous with your argument.
No,
That's
but
a common area.
It's okay, it's okay.
And Mrs. Malay allows me to do that.
I don't think you need to explain it.
It's Mrs. Malay that allows me to do that.
The law is written the way it's written, I
Okay.
think the board is ready to pass.
Okay, very good, thank you.
So I needed,
Yes, please.
Hi, my name is Lydia Lee, and I belong to Pine Park, so that's why I'm here. Years ago,
excuse me, what address, please?
3 Franklin Avenue, we had to come here because my neighbors wanted to pave our road. And we had gotten bogged down because we couldn't decide what color gravel, so it didn't get done and it got nasty. So then, I never understood, and this is germane to everything, the vehicle by which the village can interfere with a private property ownership in the associations that, does the association vote to go to the village? Or how do you even interfere with a private property dispute?
Maria, can you explain the process?
So the local law is written as such that by petition, and.
What is the local law?
The local law is section 64.
Yeah, here it is, right here. It's section, excuse me. Okay, this is chapter 64 entitled Streets and Sidewalks. And there's a section of it that talks about
Private street improvements.
how they're to be repaired if more than 50% of the property owners on the street make a petition to the village, which is what happened in this particular case, I believe.
And
the other case. And then this has happened in a lot of other cases.
Yeah, okay, I just wanted to know.
So there's a
the vehicle.
petition, and then what happens is that, once we receive that,
then the persons who are presenting the petition, usually it's someone who's in charge of the homeowners association or someone who's a neighbor on the street that doesn't have a homeowners association. They come in, as this gentleman did, for the residents of the street, and presented that petition to the village. The village then has considered this, and there's a report made about what the cost should be. And I believe in this particular case, the cost estimate was given to the village approved that. And then that
The association comes up with
the
the estimate?
association, yes, so the association goes, or the street, the people that live on the street, let's put it that way, because you don't always have an association sometimes. So the people that live on the street under this system, can petition the village. They determine what the costs are. And the village is pretty careful to make sure that we're sure everybody knows exactly what's going on. And then all of a sudden, when we figure out what the cost is, there has to be a notice given to those people who don't want to pay. There is a process.
I don't
The
understand the
recalcitrant
basic.
property owner, and that's what we're holding this hearing on today, because those folks have been given notice about the fact of what the cost will be, and this is their opportunity to be heard. But if the board votes to charge those recalcitrant property owners, then eventually it'll end up on their taxes, and the taxes will pick it up that way.
But the association roads are private property.
Absolutely.
Are they not?
They definitely are private property.
So I wonder how this.
That's why this
got
process
passed.
it's been well thought out. I mean, it's a little complicated, but I think it's fair. And it gives an opportunity for the private road to be repaired only because you folks came forward and petitioned the village to have it done in a manner and to be looked at by the village. So that's the way it works.
Anybody else?
I'm Peter Creedon. I have to speak about Shore Road at some point tonight.
Yes, we're going to finish up this
Well, later.
year.
We need to finish this hearing, please, Mr. Creed. No worries. So I need a motion to close the hearing, shown 6:56 p.m.
Second.
Thank you, Trustee Santoro. Thank you, Trustee DeBartolo Mayor. Trustee Walsh.
Yes.
Trustee Santoro.
Yes.
Trustee Nigro.
Yes.
Trustee Vitale.
Yes.
Trustee DeBartolo Mayor. Trustee Valsecchi.
Yes.
Mayor Minnikosi.
Abstain.
So the next resolution is going to be to effectuate the assessment of $568.70 to each of the following homeowners: Gordon and Charlene Beal, 5 Pine Park Avenue, Bayville, New York; Tom Levy, 6 Pine Park Avenue, Bayville, New York; Kathleen A. Wimmers, 6 Howard Road, Bayville, New York; Angelina Carbone, 2 Howard Road, Bayville, New York; Lois Nadler, 1 Howard Road, Bayville, New York. This has been presented by Tom Wilson, the representative for the association.
Can you take my name off of that? I don't want to, I'll write you a check tonight. I don't want to be vilified. I'm sick of these motherfuckers. I'm out of here. You won't even take the calculus into it, that's just wrong. Just wrong.
So, do I have a motion?
Make a motion.
Thank you, Trustee Bowser. Thank you, Trustee Nyberg. Trustee Walsh.
Yes.
Trustee Santoro.
Yes.
Trustee Nyberg.
Yes.
Trustee Vitale.
Yes.
Trustee DeBella.
Yes.
Trustee Valsecchi.
Yes.
Mayor Minnikosi. Thank you. So, the hearing is now closed, and we will proceed with the assessment.
Yeah, well, I just want to say one thing. I was told it was $350.
At this point, Mrs. Nadler, the amount has been assessed. If there's any discussions, you could have those with Mr. Wilson.
So the hearing is officially closed.
You're close, you're set.
All right, does anyone else here, Mr. Creedon, you're not here for 33 Bayville Avenue, so would you like to speak about Shore Road, you said?
Sure. My name is Peter Creedon, 12 Saltair Lane, I live at the corner of Saltair Lane and Shore Road. In 2008, I was a party to the action of Incorporated Village of Bayville versus Bitter Red. And Judge Davis, the Supreme Court judge at the time, granted me and the other parties to this litigation the unimpeded use of Shore Road. And he wrote, the court concludes that the erecting of the barricade on Shore Road was a substantial interference with the health and safety of residents south of the barricade because it interfered with their rights to fire protection and also police, ambulance, and other emergency services. The barricade also interferes with public access to Shore Road, which would otherwise be unimpeded despite its character as a private street. So, Judge Davis, Judge of the Supreme Court, in this decision, granted me, as a party to this litigation, unimpeded use of Shore Road. Last Friday, Kim Federetti put a barricade across Shore Road. I wrote a letter to the mayor, and I received a communication from my new friend Peter, the village attorney, who is a real gentleman and an excellent attorney.
We do that.
And he told me a little bit about a resolution that Bayville has made, which was dated April 22nd, 2024, which has a number of whereas clauses in it referencing Judge Davis's decision, but only those portions which address the portion of the barricade which could have impeded emergency service. So, I'm going to go to court on June 4th. I hope I don't have to sue the town of Village of Bayville. That's the last thing I want to do. Bobby Vitalik's a personal friend of mine. I don't want to waste any taxpayer money. But I don't really have much of a choice about it. My wife goes that way every day to work. She goes up to the church. She's the president of the Rosary Guild. And if we go left out of our driveway, we have to drive past the home of someone who I had arrested for stalking my wife and then arrested 7 more times for violating order of protection and come within a few feet of where that person is. So I really don't have any choice in the matter. So I just want to get some clarification on this. The first question is, did everybody read this decision before this resolution was adopted, or was it just briefed for you? We just told what that decision said. Because obviously to leave out the part where Judge Davis says the public should have unimpeded use of Shore Road makes it look like the resolution was tailored a little bit towards a foregone conclusion.
I don't think Judge Davis's decision necessarily proved that the public had a right of way. He did mention the fact that there was that the public used it, but the position of the village on these private roads, basically, is that we don't want to get involved in the disputes relating to someone who claims that they have the right to close it.
So I get that, but my question is, did the trustees themselves read the decision, or did they have it explained to them? Mr. Nigel, did you read the decision?
No, but I understand what it says, and I also don't think it completely applies to the settlement of the Villers matter.
I read the Villers matter, read the Marcia matter, I have the Villers brief here. I understand that one of the reasons for the resolution is to try and hopefully tamper down any future reverse or inverse condemnation proceedings. I get that.
Of Shore Road, I just want to be clear to anyone that's here, we're talking about Shore Road and Shore Road only.
So I get that. That part, I understand, I have to challenge it. But it's the part where it looks like it was kind of an inside deal to benefit Kevin Federetti, which is gold. But I have the answer to my first question. My second question is, am I right in my understanding that, because when I go in front of a judge on June 4th, I want to make sure I explain it to him correct. Because right now I plan to just sue Kevin Federetti and not the town. That the town is not taking any position on whether or not I can dismantle that barrier.
No, but that's the point. Our position is that if someone claims, which I think Federetti does, claims some ownership of Shore Road, if he does so, he does it at his own risk, as we indicated in that resolution that we passed on April 22. And whatever happens, it's going to happen. And we don't want to get involved in private road disputes. That's really the situation, and our position really was, as we pointed out in the resolution that we passed, was to say that Judge Davis's decision dealt with an impassable barrier. It dealt with something which was 4 feet high and had a fence and rocks and built.
I think anybody who
I
reads
may
that,
disagree, of course.
reads that
and I
decision,
respect, you and I had a discussion about that.
anybody who reads that decision can see that that's really not.
Yeah,
What
and that may be for the judge to decide if that's what you wish to do. But that's the purpose here. The purpose here was up for us to not take a position when people started to block private roads, because
I don't mean to interrupt the attorney, but it's very important that we're talking about Shore Road, because most of the homes along Shore Road, probably yours included, without looking up, you own to the high tide mark on the other street. It's very, on the other side of the street. So it's very unique. It's the only road in Bayville that I am personally aware of that the road actually goes over everybody's property in its entirety. So this is the 3rd time in 15 years that the village has been involved in a lawsuit with the closing of this road.
Yeah.
Okay. The most recent case, the village stood to lose $750,000 if we would have lost this case. And I feel that the prior building inspector did the right thing by refusing to allow the fence permit. But what are we going to do? Go to court every 5 years over somebody that wants to close the road over their own personal property? We can't stick our neck out every time on this.
I'm not disagreeing.
And when the rest of the public says we're going to close the road in front of our house, it doesn't apply. This is the only road that is actually on, and do you own the road in front of your house? Is it yours the same way?
I just patched the potholes yesterday.
So that is the point to all this. Again, it seems every 5 years we're in litigation over something. If we would have lost this case and then closed that road, people wouldn't even be able to get to their homes. I mean, I personally feel we would have won the case. I think we had a good case. But I'm not willing to go to court over $750,000. What would the taxpayers be saying about that?
I got you. Let me just say one thing as an insurance man. I was a managing attorney for the Travelers here on Long Island. I think the idea of just letting these things go up willy-nilly unpermitted is insane.
But we've won and we've lost, so.
But I mean, what I'm saying is this.
We went to court with it already and won.
Right.
But we went to court with Marchand and lost.
Here's
So
what I mean.
it could go either way.
Here's what I mean. All right? It's not if you go down there now, it's not 12 inches of dirt. It's a good 2 feet of dirt.
If I may interject, because I did ask him about that, and he claims, again, I didn't get out with a tape measure and look, but he claims that on your side, it is 12 inches. And on his side, it is not, because he plans on putting topsoil and grass in. I'm just telling you what he said. I didn't go measure it. So if that's not true.
But the thing is, here's the thing. Right? You get one of these barriers up, and it's problematic. Whose is it? How do we know Kim Rivera put that barrier up?
It's on his property.
It's on his property or his mother's property?
Both mother's property. We're not talking about Kim.
She's on the Rosengill. I can't sue her either. And we know there'd be hell of if I sued her. All right, because of Rosengill, there's somebody in the Rosengill. All right, so I just wanted to get clarification so that when I go see the judge on June 4th, I can say that I spoke to the town and I got clarification. Peter, I hope you enjoy your trip. Congratulations.
And I will see you there.
I'll see you there. Thanks, everybody.
I just wanted to interject something.
You have to step up.
I just wanted to give you or him some information. There was a similar situation.
Excuse me, I'm sorry.
My name is Suzanne DeLucy. I'm in the village. I'm sorry?
Your address, please.
14 Shore Drive.
Thank you.
I come from the village of Huntington Bay, and there was a similar issue on East Shore Road. And I don't know how they handled it, but there's no barrier on the road. And it was one particular homeowner that figured out he had the right of way to the high water mark. So you might want to look into that.
Yeah, there's one case involving the southerly portion of Shore Road or Washington Avenue, whichever you wish to call it. The Michelle against Bayville case. And there's a situation where the property owner blocked her way.
Yeah.
And she went to the Nassau County Supreme Court, and the court said she has a right of way because apparently it's in her deed. I didn't handle that case. I'm just relating to you the fact that people have certain rights of way
No, I understand that.
these
It's
roads,
really not-
and they're not that easy to determine all the time.
Mhm.
So, it's another reason why we want to keep our hands off the private road scenario.
Yeah, no,
Because
I
that's what
understand. I
happens.
just thought I'd throw that information out
What
there.
happens, what
If
happens,
you want to look into it.
man, what happens is the question of whether or not the village grants a permit for some reason, takes an action, and involves that action involves the village in a lawsuit.
Right.
The village wasn't fighting about, what would go across the road, because Mr. Villers had the right to put something across the road.
Right, no, I completely understand.
But he
I just
has
wanted-
neighbors who have, rights of way, and they can stand up, and they can sue, and they can threat, and they can be involved in a lawsuit.
Yeah.
The village didn't want to put itself in that position.
Right.
We're a deeper pocket.
Yeah, no, I understand that, and that may just be the case of what happened in the village of Huntington Bay. I just thought I'd throw it out there and somebody wanted to look
Appreciate
into
it.
it.
Thank you.
Yes.
Hi, my name is Brian Tadalgi. I live at 14 Sherry Road in Bayville. I read that article that they put up on Facebook, and I read the ruling. And the ruling clearly outlines that road, stating that if anyone put a barrier up, it is illegal under the judge's statement. I did read the response from you guys, where you said you would allow a barrier 5 feet wide by a certain amount of feet high. Now, I would like to know how any emergency vehicle would be able to pass a barrier 5 feet long, a couple of feet high. They're going to destroy the vehicles, if it's a police car, ambulance, whatever it may be. Let alone there's some kids wanting to go for a joyride and go over that mountain to say, I ran over that mountain. Also in the article, it says that any road that has been being used by the public for 10 years or more is no longer a private road. Bayville has had numerous cases of this type barrier being put on, besides the Marshland property and the other property we're talking about. You have it on a boulevard. You had it on Roosevelt and Meadow Street, off of Bell Lane and Bay Street. There are a couple different locations where Bayville enforced the law and said you had to take them down. I understand Bayville lost a couple. That happens. That's life. But Bayville has to make a ruling one way or another.
We did, we're not getting involved. It's
But
your road.
you can't just say that, because
Just
the
ask me
judge.
what we did. We made a ruling,
but-
that was our choice. The resolution was passed that we are not getting involved in barriers on Shore Road. We've spent hundreds of thousands of dollars defending cases in both scenarios, and won one and lost one. Why should we continue to spend taxpayers' money regarding a private road? If the road is owned by the people that live there, it's a unique situation to any other road available. The boulevard is not owned by the homes that are on Long Island Sound. It's a private road that they chose to close on. And you ask about the emergency vehicles. There's a letter in this folder from the fire department that they have no problem with that 1 foot high, 5 foot wide barrier. It's right in the envelope here. Okay, it's a what we call a passable barrier. We're not going to continue to get named in a lawsuit every time somebody on Shore Road wants to put up a barrier.
Well, unfortunately, that's the way the
It's
system
gonna end up
works.
costing you a lot more money in your taxes.
But it's gonna cost that either way, because it's inevitable, that somebody's gonna sue no matter what. And they're gonna go back to the judge's ruling saying that the village cannot do what you guys are doing. You guys are saying that they're being permitted to put a barrier up, and it's there. And that barrier, it's not, there's pictures all over the place of it. It's not a small barrier. Even just with the mound of dirt that's there, it's more than a foot high. It's probably about 2 feet high. Yeah, it's, I have pictures of it. It's about 2 feet high, just the dirt mound. and it goes from one end of the street to the other end of the street. So there is no way for you to get around, because if you're coming from Saltaire down the road, to the left of that mound is a fire hydrant. So there's only about 2 or 3 feet there that you can get by. And on the other side is the Fitteretti's property. So unless you want to be a jerk and drive over the property, there's no way for you to get around that
The
mound.
street in front of his house is his property.
It's.
I understand that, all the roads are the same way, but if you go.
No, not this one.
Yeah, no, I understand what you're saying, that it's the waterway.
Brian, may
Yeah.
make a comparison here, and Peter, correct me if I'm incorrect. You have 2 neighboring properties. One neighbor puts a fence on the other person's property and is claiming a piece of their property. That's a private dispute between landowners. Would you say that that the village does not get involved? Would you say this is the same situation
I
here?
think the only difference here is that you do have Judge Davis's decision, which Mr. Creedon referred to, and Mr. Creedon's position is the wording of that old decision of 2008 requires the village to get involved. Our position is that it doesn't, because that decision clearly stated that the village may get involved to remove that barrier that was sued at the time. That was way back in 2008, right?
Peter, I'm not asking the village to get involved, I'm gonna take care of it.
Yes, sir. Okay, all right. No, I understand.
Don't sue us.
What I'm trying to say to you is that in connection with that, his position, and it's going to be up for a judge to decide whether or not the village has to get involved any further with respect to that ruling that was made on Shore Road back in 2008. Okay?
But how can you guys go against this ruling saying that any road that's being used by the public for more than 10 years is no
That's
longer,
not correct, sir.
but that's what it says.
No, if you read the Marchand case,
That's a different case.
no, that's right, it's different.
Yeah.
But it involved the village of Bayville, and it involved the Court of Appeals, the highest court in the state of New York. And it clearly stated that it does not become a public road by the mere use of a public travel over the road. The village has to take position of actually maintaining it and taking charge of it and repairing it all the time. We've never done that on Shore Road. The village has never done it, based upon the history that I have. So the Marchand case is determinative of what you're talking about. It says public use isn't enough. It involves the village getting involved in repairing and taking charge of the road, putting it under their jurisdiction, just like Godfrey asked.
So you're doing snow plowing, isn't that maintaining the road?
That doesn't matter. The Court of Appeals knew that we did the snow plowing, and they also knew that we did the snow plowing on other roads. In fact, Marchand won the case on the argument of stating that the village not only did the plowing and snow plowing on private roads, but that they never took charge over it to repair them and maintain them.
And
That's what the court said. I'll send you a
Marchand's?
copy of the
Yeah.
decision if you
No,
want.
I believe you. When was Marchand's case?
The Marchand case, according to my list here that I made up, was decided on June 27, 2012.
Okay, so after, okay.
All right,
So it's
this is the
current
key
law.
word
No, no,
in Davis's decision that the village attorney touched on that you just blew over. It said that the village may remove the barrier. It didn't direct anybody to remove anything. So the village's position, based on the new resolution, is to not get involved in this.
So that's gonna happen in every
No, it's
location,
not,
they're gonna do
because
that?
this road is unique, as I've said 6 times already, that the homeowners own the land up to the high tide line. There's no other road in Bayville like this.
All right.
Okay, anybody else that would like to speak on anything other than 33 Bayville Avenue this evening?
I really don't want to speak, but I have to.
You have to wait.
I'm sorry?
Wait for
can come up, I'm just waiting for her to come back.
Howard, can you hear us?
Sure.
Okay, good. Yes.
Okay, so I'm Suzanne Delisi, number 14.
We didn't start yet.
Oh, is this related to the?
No, this is
No.
what's related to 33. No, so on 33, they will ask you, right? This is something.
No.
Yeah, he's gotta come up.
This young lady would like to speak about something other than 33.
Then I need to start the hearing, so.
Thank you.
I did in the meantime. I'm gonna keep you.
Do you need to handle something?
No, you finish first.
What is on Zoom? Yes. Oh, but next.
It's more about Howard or something else.
Before I read any notices, you want to.
Yes, go ahead.
Maria, just let me know where I'm starting. Okay, I'm Suzanne Delisi, 14 Shore Drive. I'm sure you must know what the issue is by now through the building inspector. I'm a little stymied and a little confused by the whole thing.
We're still talking about the closing of the road, or we just?
No, I'm talking about 14 Shore Drive.
What is that?
I'm having an issue with closing an open permit. And I'm kind of hoping, I don't want to read it, but I can give it to you, or do you want me to read it? It explains what it is. Okay. In 1967, my predecessor in interest obtained the village building inspector's final approval to construct an addition and alterations according to plans that are no longer in anyone's possession. The work appears to have been commenced by the applicant within the time period prescribed by the village code in effect at that time, and was never abandoned. It also appears that some modifications and attempted repairs were made at various times, including an attempted repair by my immediate grantor prior to my purchase. I contracted to buy the property with the additions and alterations at issue in a complete state of disrepair, with an inoperable heater, roof leak, mold, and in one room, no viable floor, insulation, or sheetrock, with exposed and disconnected gas, plumbing, and waste lines for disconnected toilet, bowl, sink, and washer dryer in the room. There was an electrical panel adjacent to water pipes. The ductwork in the crawl space appeared to be wrapped in deteriorated asbestos and was rusted and disconnected in areas. There was evidence of a prior rodent infestation and no indication of any prior flooding. Before I contracted to buy the property, I visited with the building inspector to see what information he had on the property. And he gave me full access to the file, and he provided me copies of the original plans. In fact, at the time, he was so amenable that I was excited at the prospect of working with him. When my title company discovered 2 open permits, my grantor's agent advised me that she met with the building inspector at the property to close out the permits. She further advised me that at the time, the permit to build a boat shelter was closed because the shelter no longer existed. But the permit for the addition and alterations could not be closed until an electrical certification was obtained and the exposed plumbing, gas, and waste lines were remedied. When I conducted the pre-purchase walkthrough, I found that the seller had shoddily installed sheetrock in one of the rooms, presumably in preparation for the inspection to close the permits. I purchased the property with a nominal credit from the seller for 2 open permits with the belief that the word open meant just that. Open and needing to be closed. There was no indication that the permits were expired at the time of closing or when I met with the building inspector at the property to confirm what I needed to do to close the one open permit. At that time, the building inspector advised me that I had to put the bathroom back to what it was in the original 1953 plans, that I could not have the laundry room and sink for which the plumbing was already there. In the exact opposite, he said that it was not permitted to use the larger opening for the original garage door replaced by a smaller entry door. Before moving in, I had my former contractor clean up the interior of the property as best he could so that I could live in the property to feel the space to give me time to decide what I wanted to do. Tear it down, lift it, get a new appraisal for an as-is repair. This is about the 5th handyman special I've owned and renovated for my own personal use. The work for this property necessarily included mold abatement, removal of insulation with old mice, feces, and nests, removal of old paneling, painting, and installation of porcelain tile. At the same time, my contractor removed all the old kitchen cabinets and appliances to access the mold. After that, I made a conscious effort to hire local contractors. First, I retained Taylor Tree Service, who obtained a permit to remove encroaching trees, and then Houghton Brothers to restore the yard to its natural state. The property is adjacent to the county open space with a wildlife sanctuary. I then retained Rocco T. Ronaldo Jr. Inc. to correct the electrical deficiencies and to bring it up to code. This necessarily included relocating the electric panel away from the water pipes and removing sheetrock and insulation to locate and replace the mice-eaten wiring. At about the same time, I had a new roof put on and retained Tri-County to install a new HVAC system in the attic and to remedy the plumbing deficiencies at issue with proper permitting that I was assured they would obtain, which I later found out they had not. When the HVAC install was near completion, I went away for 2 weeks, during which time the local contractor I hired to remove and replace the sheetrock took it upon himself to reinforce the inadequate ceiling beams in one of the rooms at issue and to replace them entirely in the other room at issue, despite my instructions to him that they could not be altered. When I was away, the plumber advised me that the building inspector needed to conduct a pre-plumbing inspection before he could complete the heating, so that it would not have to be exposed to the rust of asbestos in the ductwork in the crawl space overhead. I arrived home the day of the inspection only to be subjected to an uncalled for tirade by the building inspector because I said that I was working to close the open permit. That was the first time I was told that it was expired, and my question as to why was never adequately answered through today. It was not until the plumber interceded that the building inspector calmed down, and talking only to the plumber gave his directive that he was shutting down the job until he received a letter from an architect stating that the work being done was to correct deficiencies. At that time, all work ceased on the property while I endeavored to get the requested letter. But before I did that, I went to see the building inspector to see the records and reports of the inspections he had conducted. At that time, he denied having conducted any inspections and said there were no reports, and that if I wanted to see anything, I would have to submit a FOIL request. This struck me as odd, since when I was not a resident, he gave me complete access to the file, but now that I'm a resident, I had to submit a FOIL for the same access. I confirmed that I had to do this with the village administrator, who stated that I did, so I submitted a FOIL request with the statute under which I was submitting it. This appears to have given the building inspector a heads up of what he had failed to do, and the next time I walked into Village Hall, about 3 weeks after he issued the verbal stop work order, he handed me a post-dated notice of violation with less than a week to obtain a permit to continue the work or risk getting a stop work order or worse. After that, I called an architect who drew up plans required for a grant to install a more environmental septic system at the property. After meeting with this architect, he went to have a private meeting with the building inspector, instructing me not to come along, stating that the building inspector would not like it if I came. A few hours later, I got a phone call from the architect who said that the building inspector wanted me to get a new appraisal to apply for a new permit under the FEMA 50% rule. The architect also stated that he could not help me with this, but that I should call the appraiser and architect the building inspector recommended, and for whom he provided the contact information. I obtained the new appraisal from the appraiser recommended by the building inspector and met with an associate from the architectural firm the building inspector recommended. After weeks of working with the associate architect, the owner of the firm called me for more information. In preparation for talking to the building inspector. After speaking with the building inspector, he said that he could not get involved and had no experience with FEMA. I then endeavored to obtain a letter from another architect recommended by my contractor. The same thing happened with the building inspector, ignoring his directive for me to get a letter stating that I was correcting deficiencies. Despite his relationship with my contractor, this architect disappeared and did not return my calls. I then retained a permit expediter who said he had handled a similar matter in the village, so knew exactly what to do. I notified the building inspector that I retained a permit expediter on the date the notice mandated I get a building permit. And almost immediately, the permit expediter received a phone call from the building inspector, who gave him the same instructions he gave the 3 architects, which was not what he told the plumber and me at the time he gave the verbal stop work order. 2 months later, when the permit expediter provided me with a set of repair plans, he said he was afraid to submit them to the building inspector because it was not what he told him he wanted. But he knew what he was retained by me to provide and submit. The permit expediter told me that the building inspector informed him that I only paid $600,000 for the property, at which time the permit expediter advised me to retain legal counsel. I then retained the law firm recommended by the permit expediter to help me close the permits with vested rights and provided them with all the background information concerning the property and the building inspector's ever-changing demands as requested by them. Without speaking to the permit expediter who recommended the firm, the attorney arranged a meeting with the building inspector where again, I was subjected to a tirade by the building inspector, only to witness yet another man calm him down and continue the conversation as if I was not there. The tirade included the building inspector letting loose his unbridled rage that I had the audacity to buy the property after he had scared away 6 other buyers by reading the new riot act that he claimed to have read to me. Since then, I have severed ties with this attorney who did nothing to stop this tirade, and then instead of retaining another attorney, I thought I would bring the issue directly to you. From what I understand, I am one of a long line of residents who has had problems with this building inspector. Regardless, I'm trying to figure out why a board of trustees of whom I've heard nothing but really unbelievably great things about would condone this kind of behavior from a building inspector, especially one who does not appear to want to put anything in writing despite the requirement to do so under the village code, nor, according to the Attorney General Formal Opinion number 9540, does he appear to meet the residency requirements for being a public officer with sovereign powers. With that said, I simply would like a reasonable explanation as to why the 1967 permit for the addition and alterations does not provide vested and or grandfathered rights to do the work necessary to close the permit. After which, if necessary, I have no issue with submitting an application for a new permit under the FEMA 50% rule to do any work that would not be included in closing out the permit. Or if I choose to lift the house and renovate. To date, I have invested over $700,000 in the property, which may be considered substantial expenditures and substantial construction for which vested rights accrue under a valid permit, as stated in the matter of R.C. Andrews versus the town of Patterson. I'm not going to go into the numbers. In the 1967 permit, if the 1967 permit does not provide or does provide vested rights to close it, I would like to continue to do the work to close the permit and repair the subject area in a like-for-like manner. If the 1967 permit does not provide vested rights to close it, I would like a building inspector who meets the residency requirements to identify the health code and building code violations that exist today as they did at the time I purchased the property, most of which is documented in my engineer's inspection report obtained prior to purchase. It is my understanding that correcting health code and building code violations are an exempt expense under the FEMA 50% rule. I moved to this village after having a very difficult time in a number of instances, just to live in peace and relative obscurity. I'm distraught that I have to be before you. I'm not a lawbreaker, I'm not a criminal, and at this point I am very adverse to being treated like one by this building inspector. Under no circumstances do I want to subject myself to any further harangues, and for that reason I would like to be spared any further contact with the present building inspector. And if that is not possible, I'm requesting any and all contact include at least 2 trustees, preferably the mayor and the deputy mayor, with all directives provided to me in writing. Thank you.
If I may, it's hard to give any sort of opinion without seeing everything in person. I happen to be a real estate attorney and I do this for a living and deal with closing out permits all the time. And
Yeah.
One thing I always tell clients is if you open up a permit, close it as soon as you open it, because if you wait 20 years, 10 years, you're going to have to bring it up to current code. I don't know what the condition of the property was or what the permit was for, so it's hard for any of us to
Well, I'm not
make a
asking for
decision.
an immediate
I am
answer.
happy, not as a real estate attorney, not as an attorney, but as
Right.
a trustee, to help you oversee with the building inspector. I've done a lot of work with him over the years, and I have not seen this behavior in him. That's my personal experience,
Yeah.
and clients that I have sent to him as well. But like I said, without sitting down and really looking at the actual paperwork, it would be hard.
No, I
in this
completely
order.
understand that, and I'm not asking for an immediate resolution. However, I did move in to this house in September, and I have lived with half of the house. And it's getting a little long and unexpected, when I have always been trying to do the right thing. I had sent him several emails asking what I needed to do. I visited him several times, and
So he just went away today, actually, for a rather long vacation.
Yeah.
So, if you leave your telephone number when he returns,
well,
I
I'm
will
gonna
meet
leave
with
this
him,
with you.
and I will contact you personally.
Thank you, I appreciate it. Oh, I put it on board.
Is it phone number? You have your phone number?
I'm sorry,
Do you have your phone number?
I do have my email. Yeah, thank you very much, I appreciate it.
Yes.
I hate to say this, but I just want to support this woman. I've been there with the tirades and the lack of understanding and research. I've been there, and it was horrible.
Okay,
Are we ready to begin?
we are ready to begin.
Karen, we're going to begin our hearing this evening. I'll read the notices. Notice is hereby given that the Board of Trustees of the Village of Bayville will hold a site development plan hearing on Monday, May 20, 2024 at 6:40 p.m. Let the record show it is 7:35 p.m. at Bayville Village Hall, 34 School Street, Bayville, New York, 11709. The purpose of said hearing is to review and, if the findings conclude, to approve the proposed site development plan of the properties located at 33 Bayville Avenue, Bayville, New York, 11709, formerly known as the Steve's Pier 1. The following parcels are the subject of this hearing. Section 29, Block D12, lots 1 through 4. Section 29, Block D, Lot 123. Section 29, Block 82, Lot 2. Owner of record, Bayville on the Sound 1 LLC. All interested parties will have the opportunity to be heard at that time by order of the Board of Trustees. Village of Bayville, Maria Alfano White, Village Clerk Treasurer. The notice is dated May 6, 2024. For the record, there is an affidavit of publication. There is an affidavit of posting. There is an email for the surrounding villages who were noticed of the hearing and sent the site development plan. Nassau County Department of Public Works also reviewed the plan and have submitted their comments to the village. At this time, I'll turn it over to you, Mayor, Board, and we have Howard Everett as Special Village Counsel.
Thank you. I believe Chris is rendering on 28. Yes. Thank you all for coming. I know we've worked on this for, it's a project's been in the works for a long time, but together for almost 2 years, and it's nice to finally get to this point. I think you have a beautiful rendering there, and we look forward to hearing what else you have to say, so great.
Good evening, Mr. Mayor, members of the board. My name is Greg Kalnitsky. I'm with Porcelli, Deacon Girana, 333 Pearl Ovington Boulevard, Uniondale, New York. We're here on behalf of Bayville on the Sound 1 LLC. I'm joined by one of the principals of the corporation, Mr. Leonard Gross. I also have Mr. Matthew Aylward and Mr. Kian Cody from RN Engineering, and Mr. Glenn Cherevny, our design professional from GRCH Architecture. Okay, the site is 33 Bayville Avenue, and it consists of 2 groupings of lots. There is a northern restaurant lot located north of Bayville Avenue, and there is a southern, what we will call parking lot, which will be used for parking. It's located in the business district, and the proposed premises is a 1-story, 150-seat, 5,940 square foot restaurant. It's adjacent to the intersection of Bayville Avenue and Bayville Park Boulevard. The proposed location was the previous site of Steve's Pier 1, another restaurant which unfortunately went out of business some time ago. We're before the board for site plan review of a new and exciting concept that we hope will be embraced by the village. We're pleased to present to you the Beach Barn, which is the name of the concept. This will be as I stated previously, 5,940 square foot restaurant, which will be a family-oriented restaurant featuring upscale seafood items such as lobster rolls and raw bar selections in a relaxed beachside environment. While seafood will be emphasized, there will be options for the entire family, which include a kids menu as well as many non-seafood options such as burgers, flatbreads, pizzas, and fajitas. The restaurant parcel will provide ample parking with 22 parking spaces on the restaurant parcel, along with an additional 38 parking spaces on the parking parcels to the south. By way of reference, this will provide almost double the parking spaces required by the village code, which is at 33 stalls. That's what the requirement is. And the ratio is 1 vehicle to every 3 patrons. Restaurant management intends on providing valet parking during the anticipated peak usage of the restaurant, which as of now is estimated to be Friday through Sunday during the peak summer and warmer months, and otherwise whenever there is a catered event on premises. With the valet plan, which my colleagues from RM Engineering will present to the board shortly, the site can accommodate up to 80 vehicles, which provides the ability to park a car for every 2 restaurant patrons. The flow of the site is such that a patron can search for parking on the restaurant parcel, and in the event the restaurant parcel parking spaces are occupied, they will circle around the premises and wait until they can safely traverse Bayville Avenue to access the parking parcel to the south. There is a signalized traffic device to the east of the premises, which will safely provide cover for this maneuver. Regardless of the season, there is a 150 patron occupancy limit. And with respect to the outdoor space, you'll notice that there is an area to the rear of the premises. It will be furnished as a lounge area in the warmer months, containing tables and umbrellas. The intent is to use that outdoor space to enhance the patron experience during periods of nice weather, providing a bar and dining area directly abutting the Long Island Sound. Despite the availability of the outdoor space, the restaurant activity will predominantly occur indoors. There will be music played on premises, consistent with other waterside family restaurant establishments, which will be predominantly played indoors. Every effort will be made to mitigate noise and any impact on the neighbors. The structure of the premises itself will feature materials that are designed to mitigate the impact of noise. The rear of the premises has garage door-like openings, which permit the entire rear of the premises to be exposed so that all patrons can enjoy sweeping views of the Long Island Sound. In the event that there is music played at the time the rear garage doors are open, the music will be directed outward towards the sound so as not to impact the community. While there is a designated space on the site plan for live music outdoors, that space will be rarely utilized, reserved only for certain occasions and catered events. And in the event there is live music, the stage will be directed westward, where there is vacant land and a beach, so as not to impact the residents of the community. The proposed hours of operation for the establishment will vary by season. During peak months, the proprietors intend to remain open 7 days a week, maintaining regular service hours from noon to midnight. By midnight, management will take action to indicate to patrons that the restaurant is closing, such as lowering the music, raising the lights, calling for the last call, and closing the kitchen to service. And during the off-season, the proprietors intend on being open from Thursday through Sunday or for special and/or catered events. Of course, at this juncture, it's a bit uncertain as to the demand during the off-season, but if there is a demand, the proprietors intend on meeting that demand. Sanitation service will be provided by private carter, which will arrive on the site during off hours and remove refuse from the designated refuse area on the southwest portion of the restaurant line. This will occur approximately 2 to 3 times a week, depending on the volume of sanitation. Deliveries will occur during off hours as well and consist of food deliveries, beverage deliveries, delivery of a small amount of kitchen linens, and possibly linens and other items for catered events. They will enter the site on the restaurant parcel and pull close to the restaurant and make their deliveries and circle around the premises to go back out to Bayville Avenue and exit by turning right. I'll note that on the site plan, you cannot make a left turn exiting either the restaurant lot or the parking lot to the south. Food will be delivered by standard restaurant supply box trucks, such as those utilized by Cisco, and beverages are typically delivered by large vans. Linens will also utilize similar vehicles, and we anticipate that these types of deliveries will occur 2 times a week, once before the weekend and once after the weekend. Employee shifts will occur in 2 shifts, one from 11 a.m. to 5 p.m., and then the other from 5 p.m. to close. The proprietors anticipate hiring 25 to 30 employees, with approximately 15 employees working per shift, depending on demand. Wastewater on site will be handled by a subsurface septic system to treat all the wastewater on site, and stormwater will be contained on site by a subsurface stormwater collection system. To tell you more about the operation and technical details of the site plan, if it may please the board, I'd like to invite Matthew Aliard from RM Engineering to go through the site plan as well as answer any technical questions you all may have.
Good evening, Matthew Aliard, R&M Engineering. Any questions you might have on the site plan, please feel free to ask. Greg pretty much covered everything that I was going to discuss. Parcel itself, as you guys are probably likely aware, if we could change the plan there. Yeah, just go over to the. That's perfect. Or the color. Yeah, this is the color. It's great. This one? Yeah, that's fine. Right. So what we're seeing is. That's fine. As Greg mentioned, customers are going to come in this way into the property, circle around, find a parking spot. If parking doesn't exist, they will cross over Bayville Avenue, come down and find a parking spot in here. During the times that peak operation, they're going to, and can't think of a word, but they're going to have a valet parking program. So customers will then pull in here. Valet will take their car from underneath the awning, stack cars here as more cars pull in, and then the valets will move the cars over to the other side of this lot. All right, as Greg mentioned, we're going to get each stalls. It'll be a 1-to-2 ratio for the valet. We'll get 31 on the restaurant side and 49 on the south side parking. As you mentioned as well, deliveries will come in off of Bayville during the off hours when there are no patrons, so there will be no cars in the parking spots. The deliveries will have free access of the site, as well as refuse. Refuse will pull in, back out, get the refuse enclosure, and then proceed up to Bayville Avenue. Any questions you might have, I'd be happy to answer.
The lighting in the parking lot.
Yes.
What is that? It's going to be low level?
All low level lights, dark skies compliant.
Okay, great.
Yep.
And so regarding the parking, you mentioned how many employees, about 20?
There's going to be 25 to 30 total employees, and there's going to be approximately 15 per shift depending on demand.
Okay.
They will be directed to park in the southern parking lot. Right, in the southern parking lot.
But it's ample parking, I mean.
For the employees and the
If they were
customers,
going
that's what she's asking.
towards the restaurant, then.
Yeah, there'll be parking.
Yeah, so they'll be in the south parking.
They're going to be directed to park somewhere over here towards the westwardmost portion of the southern parking lot, so that the customers that come in can have access to the best spots.
To the valet, and I just want to know when.
Did you say you could only make a right out of the?
Correct. Due to the proximity to the signal that's there,
Yeah.
all movements will be right now. Right, so it'll be
Yeah.
eastbound out of the south, and westbound out of the north.
Excuse me, I'm a little concerned about the valets just, or people, or anybody just crossing right over. Shouldn't they maybe have to, it's not convenient, but make a right and then come up around rather than crossing right over Bayville Avenue to go into, from the north lot property into the south lot?
To walk. Yes.
No, not to walk. No, so say someone pulls into the north lot, the one with the restaurant, and there's no parking, so they come out, or even the valet, someone, they take a car, rather than shooting straight across, into the south lot, will they need to have to turn right, drive down Bayville Avenue, turn around, and come back?
No, they will. They will be able to proceed across. There's just no left turns.
Is there going to be a marked crosswalk there?
Yes, yes, there'll be a crosswalk at the signal installed as well as pedestrian signals, so it'll be an actuated push button.
And the county has approved that?
We have discussed that with the county. We are in coordination with the county.
I'm concerned
That's
about the
all at
park.
the light, everything's at the light, the crosswalks and.
The crosswalk will be at the
Yeah,
light.
not where you
No,
cross
we
it.
do not want anybody crossing.
No, okay.
I'm concerned about the cars crossing between. That's what
Correct.
I'm concerned about.
It will be-
I'd rather than make a right, and although I myself would hate having to do it, but I think it's safer to make a right and go down and turn around on Bayville Avenue where you can in front of the beach, and then come back into the other lot.
Which is kind of a nightmare anyway, because now you're coming across, it's the same.
No, but I'm concerned about shooting straight across with the traffic coming, because that can get a little congested there.
I'd rather them shoot straight across and go down to the stands.
I don't know if you legally
Turn
can,
left
it's
and
double
people
yellow.
coming out parking.
Well, you're gonna have cars, if the light turns, you're gonna have cars parked there, so I don't know if they can come right across at the red light. I live on Bayville Park Boulevard, so.
Yeah, that'll be worked out with the county.
Okay.
As far as this, we initially proposed a different access arrangement. We met with the county. We've agreed upon this. And this is
If
essentially
the county's okay with it from a safety standpoint, then
Yeah.
I'm
And this-
fine. That was just my concern.
Yeah, and those are the movements that we discussed with the county, and that's how we came up with the no left turn, because if someone did try to make a left turn and there were cars queued at the traffic signal, they'd be blocking the way.
Yeah, that was the right way to go.
Right, right. So, and then just so you know, the valet is, it's either gonna be park your own car or it's gonna be valet. It's not gonna be one or the other. It's gonna be, we'll park our own cars or the valet.
Oh,
park your car.
on either lot, on the north and south lot?
Yes, correct.
So it's valet or
Nothing.
or do it yourself?
Correct.
Just with the parking, getting into the south lot, if you're going west on Bayville Avenue, can you make a left turn, or do you have to go down and around?
We're not prohibiting that movement. So yes, you
You're
could,
not
you
prohibiting
could make
a
a
left
left turn and come
Come
off.
on, Bayville Avenue.
Correct.
You just can't come out of each lot and make a left turn.
We don't want.
No, I know that, but how it is now, the lines are double yellow, preventing a turn.
Correct.
But that's the county.
And yeah, and this is what we're showing here is
Yeah.
the current, essentially the
Yeah,
current.
the current.
Bayville, we're gonna have the crosswalk that'll go across as well. It's probably broken W.
Yeah.
Thank you, Mr. Elward.
Thank you.
One item that I neglected to mention, and I spoke with council, and he wanted me to mention this to the board, is I just want to direct your attention to the area of the seawall, which is the northernmost portion that's adjacent to the riprap by the Long Island Sound. The applicant has agreed, if this matter is approved and we obtain all necessary approvals, regardless of the fact that it's beyond his property line, we are willing to enter into an agreement with the village whereby the applicant will maintain that entire seawall and ensure its upkeep. So I just wanted the board to be aware of that, and I spoke with Mr. Avertine, who has approved the agreement that I provided to him as the form, so it's ready to go. At this point, I'd like to invite Mr. Keenan Cody to give a presentation to the board regarding a traffic and parking study. I'm aware that the board is in possession of it and has reviewed it, so he'll give a high-level overview, and if you have any questions, he can address them at that time.
Good evening, Mayor and members of the board. My name is Keenan Cody with R&M Engineering. Our office is at 50 Elm Street in Huntington, New York. We do have a copy of this, so I'm going to go through sort of briefly and touch on each aspect. First, I'd like to discuss the parking. As we stated earlier, we do not need a parking variance for the site. We are almost double the required parking. We are providing valet on site up to 80 spaces. In order to bolster our claims about the parking being sufficient, we did provide a comparative analysis between Teller's in Islip on Main Street, which is a similar quality of restaurant that we'd expect for the site. Based off that, we did observations back in 2005 and in December, and based off that observations, they had 180 seats at that time, where we're proposing 150 seats. They had a maximum parking demand of 94 vehicles, which occurred on the Saturday evening. It translates roughly into 0.52 vehicles parked per seat. Applying that rate to the 150-seat proposed restaurant results in 78 vehicles parked. With the 80 valet spaces, we believe that's adequate. The 80 spaces is also fairly conservative. We did space out the cars a little bit to give the valet a little bit more room, but more cars could definitely park on site than the 80. Beyond that, we don't really have any issues with the parking. We see the demand, and we believe, based off our observations at other similar quality restaurants, it works very well. In addition to the parking, we also looked at the traffic and performed a brief traffic capacity analysis. First, we consulted the Institute of Transportation Engineers, the ITE, and their trip generation manual, the 11th edition. The ITE is an organization which collects data nationwide and creates rates for both parking and trip generation. Basically, it outlines an estimate based off different land uses, fast food restaurant, bowling alley, things like that. It piles data and develops rates, essentially telling you, based off different independent variables, what you'd expect parking and traffic-wise. For this site, we used Fine Dining Restaurant, which is under their provisions land use code 931. We performed a trip generation, which is essentially a methodology for developing and entering and exiting traffic volume for an hour period. We estimated for the midday peak period, which we expected 44 trips, the PM commuter peak period for 42 trips, the PM dinner period for 44 trips, the Saturday midday and Saturday dinner periods for 50 trips each. And that's based off their standards and their data collection of other restaurants that they qualified as fine dining restaurants. The independent variable was chosen as seats, as that's our limiting factor in this equation. We did note that the site is fairly unique. We have the north and south lots, so we will have vehicles entering and exiting the two lots as you've all gone over. So the trip generation is going to be slightly inflated in the sense that vehicles will be at this created intersection will be entering and exiting the site more often than that base trip generation I just discussed. We won't get into all of the numbers because there's quite a lot of them, but essentially we expect the north driveway to experience a little bit more traffic, especially in the valet situation, as everyone will have to be coming up and going in, and then the valets will have to be going out. So at that, we'd expect more entering and exiting, and a little bit less at the southbound. What we did with this information is we use this information along with state data. Now the state collects data along many roadways, and as this is a county roadway, they're very likely to collect data here. There's a state count station about 250 feet east of this location, which they collected data in 2023. They collected weekday data, and that weekday data we averaged out between the Monday and Wednesday, which is what they collected. And we use that to develop the through volumes on Bayville Avenue, essentially the traffic going eastbound and westbound, and then use the trip generation that we developed for each of the north and south driveways to create the turning movements at that intersection. So we simulated the intersection as best we could in the future condition. We used the software called the Highway Capacity Software, the latest edition. It's developed by a company in Florida that develops traffic capacity software to essentially give intersections a letter grade on how they operate. So an A means the intersection operates really well, a B, less well, C, less well, all the way down to F, which is overcapacity. Based off our analysis using that AADT data and the base trip generation, we found that the unsignalized intersection created by the two driveways at Bayville Avenue resulted in levels of service below capacity, below capacity, with the highest grade being C. Everything else was A's and B's. So it operated rather well. In that situation, we did include that crossing movement of the valets going across both southwards and then northwards back up. Based off that and the site distance around the site, we didn't see much issue. Both to the east and west, you can see quite far, well over 400, 500 feet in both directions. The road's fairly straight and level over there. So we don't see any issues with the crossing movement. In terms of how it operates with the light right there, that signal, east-west wise, once the east-west phases are going, it's just normal traffic flow along the road. We expect the crossing movement to be no different than any other crossing movement at a two-way stop with an uncontrolled free-flowing main street. When the light goes, we just advise that the valet is going back north or anyone turning out of the site. We'll just wait until the phase ends. I know it's a residential roadway, so the signal most likely gets called less often, and most of the time, the traffic trapping along Bayville Avenue will be the dominant traffic, which will allow that crossing movement. In terms of how many vehicles we expect going out of that north driveway from the valet, we only expect 13 vehicles during an hour, which averages out to be one vehicle every 4.5 minutes, which it's not really going to be that much of an issue. If you only had one vehicle traveling down your road every 4.5 minutes, you'd probably not notice too much. It's the same sort of idea for the driveway. They're only crossing the 2 lanes itself. It would be the same as essentially making a left turn across 2 lanes on like a Jericho Turnpike, which is a fairly common movement. I'm happy to answer any questions, but ultimately we came to the conclusions based off the data that we had that there would be little impact on the traffic flow along Bayville Avenue and that parking on site would be adequate.
Will you be doing anything about the lighting along Bayville Avenue, or can you?
It's a county control signal. All we can do.
I don't mean the signal. I mean illumination.
Oh.
The illumination is also under the jurisdiction of the county when it's adjacent to the county road.
I understand that. You indicated to them you intend to, or ask them to allow you to increase the illumination. People crossing further west from the town parking lot to the stands area at the restaurant. There's a marked roadway. There's a crosswalk there. You can't see them because there's no illumination along Bayville Avenue, or not insufficient illumination. My question was, you're going to have more illumination since you will have people crossing from one side of Bayville Avenue to the other. You have illumination there to make them visible as they enter into the roadway.
I just spoke to Mr. Aylward. We will definitely have that discussion with the county to see what we can do against some lighting.
There's it's a crosswalk. It's
There will be.
actually, yeah, that's not where he's talking about.
No, so just for clarity, but the 2 crosswalks that are west of there each have a dedicated spotlight of their own. So if we need to add one at the crosswalk, then the county will do it. They're on the other crosswalk. So.
On this one, but aren't those green circles lights?
No,
those are trees.
Or the ones,
The lighting is on
the 3 along Bayville Avenue?
For the trees.
Okay.
The county will add a spotlight on the crosswalk if they're putting a crosswalk.
That's all I wanted to know.
Unless the board has any additional questions, that's our presentation. We hope that you will view the application favorably. We believe this is a wonderful use of the site that will be an amenity to the village and its residents for some time to come.
Thank you.
Thank you.
Thank you.
Anybody have any other questions?
I think it's a beautiful design.
I like the design.
Yeah, me too.
Do you have a picture of the back? of the building?
Not in color, just a 2D drawing.
Oh, I was just curious.
Well, I think it should be, it was probably submitted.
No.
No?
It was
That's
submitted.
okay. I was just curious.
Architecture's not important.
No, it looks great, thank you.
Have you completed your application to the Committee on Architectural Review?
Sounds good.
There's a series of additional approvals we have to get from the village. I think the next step, should the board approve this, is going to be the ZBA as well as whatever other boards. We do have to get some minor variances with this site pertaining to the retaining wall, its location and height, as well as this accessory structure in the rear yard. So minor variances, but we will comply with everything the village wants.
You showed me a picture of the rear of the property, it looks great.
What's the next step?
You want to open?
Yes, so they're going to employ you. Yes.
Should I come up?
Yes.
Please state your name for the record, please.
Suzanne Delisi,
What is spelling your last name for me?
D-E-L-I-S-I.
D-E-L-I-S-I. Okay, address?
14 Shore Drive. I had a couple of questions. Is there going to be a happy hour? I'm not asking for that reason.
You need to direct the questions to the
Okay,
board.
no, I
and
just
they
wanted to
determine.
know if there was gonna be a happy hour, and the reason why I'm asking is because, I live near Prime in Huntington, and, at some point, the happy hour was so busy, and they had valet parking, and the reason they got rid of the reason why they got rid of the happy hour was to get rid of the valet parking because the insurance was so high. There were so many accidents.
That's a tough road there. Our boat's right next door there.
Oh, yeah, no, I know.
I rode and watched many happy hours there. That's a very tough parking area as well. They don't have a lot of parking.
No, they do. They have the same thing. They
The
have some.
restaurateurs here.
Also,
I think that'd be a good.
We are
problem.
very family oriented. I have two other restaurants.
Can't have this dialogue. Yes, it doesn't work for the stenographer. You need to identify yourself, Mr. Gross.
I'm sorry.
No worries.
Leonard Gross. I'm the owner. I have two other restaurants. The way we have a happy hour and the environment in the restaurant is not crazy, it's very family oriented, it's very kid oriented. If you have a 5-year-old playing in the sand over in the sandbox, you're not gonna get drunk and stupid. And we've never had an incident in either one of the restaurants at happy hour. It's a very calm happy hour.
Thank you.
It's
Good
just,
to know.
yeah, it's a total different environment.
I've been to your restaurant in Belmore and you have no parking.
0. Yep.
Okay, so my other question is it, I didn't really understand if it's going to be valet parking or not, because at one point, I believe I heard somebody say it was gonna be one or the other.
When we have, no. When the intent is to have a lot of weddings there and use it as a wedding venue. When we have the parties and we have things like that and the volume is high, we'll have valet parking. If it's not needed on a Monday or Tuesday, you will not go out of your way to have valet parking if it's not needed.
Okay, sorry. Does the valet is that included in 25 to 30 employees, or is it gonna be, a private company that handles it?
Yes, it'll be a private company.
Okay. And then my other question is, that grassy lawn to the right, is that a paper road?
No,
No,
that's
that's-
part of the parking lot, the way it is now, but it's currently blacktop.
No, to the right, there's a grassy area. No, by the restaurant. Yes.
That's gonna be houses.
Oh, it's
They're
someone
approved
else's
already.
property, so it's not a paper road. There's a paper road somewhere over there, isn't there? Or maybe by the other Soundview catering? No? Okay. That's no, I have one other question. Can you access this from the beach? From a public beach area and vice versa?
No.
Okay, that's it.
Thank
you. Thank you.
Anybody else?
So,
However, it appears we have no more public comment at this time, so I'd like to ask you, is there anything else we need to cover before we close the public hearing?
I don't believe there is, no.
So I'll close the public hearing, then we'll proceed with the requisite secret
Correct.
resolution. Okay, so at this time, which is 8:07 p.m., I'll take a motion to close the public hearing.
I'll make the motion.
Thank you, trustee
I'll
Santoro.
second.
Thank you, trustee Bartolomeo. Trustee Walsh?
Yes.
Trustee Santoro?
Yes.
Trustee Nigro?
Yes.
Trustee DiNatale?
Yes.
Trustee Bartolomeo?
Yes.
Trustee Valsecchi?
Yes.
Mayor Minicozzi?
Yes.
The next resolution, and do I need H1 to do any presentation prior to the?
Well, let's do the appointing of the board first.
Okay.
And then we'll list it, and then we'll have H2M make its recommendation.
Okay, so the next motion is to designate the Board of Trustees as the lead agency in this matter.
I'll make a motion.
Thank you, trustee Valsecchi.
I'll second.
Thank you, trustee Santoro. Trustee Walsh?
Yes.
Trustee Santoro?
Yes.
Trustee Nigro?
Yes.
Trustee DiNatale?
Yes.
Trustee Bartolomeo?
Yes.
Trustee Valsecchi?
Yes.
Mayor Minicozy.
Yes.
At this time, I need a motion for a resolution to declare this an unlisted action. Under secret.
I'll make the motion.
Thank you, trustee Santoro.
Second?
Thank you, trustee Valsecchi, trustee Walsh.
Yes.
Trustee Santoro.
Yes.
Trustee Nyberg.
Yes.
Trustee Di Natale.
Yes.
Trustee DiBartolomeo.
Yes.
Trustee Valsecchi.
Yes.
Mayor Minicozy.
Yes.
At this time, Howard, should I add?
What I'll say is that this time, prior to the board rendering its decision on environmental impact, I would request that H2M address the board. H2M prepare part 2 of the SECRA environmental assessment form and analyzing environmental impacts and preparing a recommendation to the board to adopt a negative declaration, meaning that there will not be severe environmental impacts. And I would at this time request, I believe Lisa Rittmers is present, and she can summarize her analysis and recommendation at this time.
Okay, thank you, Howard. Lisa, would you please identify yourself for the stenographer?
Lisa Rickers, H2M Architects and Engineers. Would you mind spelling that? RICKMERS. Thank you.
Evaluated the short environmental assessment form submitted by the applicant. Is considered the part 1 for, based on the requirements of Article 8 of the Environmental Conservation Law, establishing the State Environmental Quality Review Act, SECRA, and completed the part 2 and 3 of the short environmental assessment form using the state environmental databases and all pertinent information from the site plan and other sources. The part 2 did not indicate any areas, did not identify any areas of expected significant environmental impact based on our review, and therefore we have prepared a written negative declaration for the board to consider and adopt. So,
Thank you.
questions?
Anything else, Howard, for?
If the board has a question.
Anybody have any questions?
No. Thank you.
So as per the recommendation of H2M,
We request that the board pass a resolution enacting a negative declaration under C.
motion? Thank you, trustee Santoro.
I'll second.
Thank you, trustee Bartolomeo. Trustee Walsh?
Yes.
Trustee Santoro?
Yes.
Trustee Nyberg?
Yes.
Trustee Di Natale?
Yes.
Trustee DiBartolomeo?
Yes.
Trustee Valsecchi?
Yes.
Mayor Minicozy.
Yes.
And at this time, there being no other items to be covered, we will ask the board if they want to approve and pass a resolution approving this site plan.
Correct, and a draft resolution has been furnished for the board's consideration. And one of the main aspects of that is it requires compliance with any and all approvals, any additional approvals that would be required from the village, county, and state in connection with the proposed development.
Thank you.
Any questions on that, board?
No.
And I'll take a motion to approve the site plan in accordance with the draft resolution.
I'll make that motion.
Thank you, trustee Natale. Thank you, trustee Nyberg. Trustee Walsh?
Yes.
Trustee Santoro?
Yes.
Trustee Nyberg?
Yes.
Trustee Di Natale?
Yes.
Trustee DiBartolomeo? Yes. Trustee Valsecchi?
Yes.
Mayor Minicozy.
Yes.
Thank you. Thank you, Howard.
Thank you very much.
I'll speak to you
Nice
later
evening,
in the week.
everyone.
Have a good
Thank
evening.
you, Howard.
Good night.
Good night.
Thank you.
Motion closed.
And unless we do close the meeting at this time, unless you have any other business. All right, so then I'll accept the motion. I take a motion.
I make a motion.
At 8:12, yeah, thank you, trustee Bartolomeo, thank you, trustee Santoro, trustee Walsh,
Yes.
trustee Santoro,
Yes.
trustee Nyberg,
Yes.
trustee Di Natale,
Yes.
trustee Di Bartolomeo,
Yes.
trustee Valsecchi.
Yes.
Mayor Minicozy.
Yes.
Thank you. Thank you, gentlemen.
Thank you.
Howard,
I think so.
Right? Thank you.
We're not done yet.
I haven't heard of that. I just
just heard that, you know, I do it all the time, you might experience that.
Exactly, that's the That's the high
So we'll have everybody put it together, construction drawings.
Yes, you do have to. Okay. Sorry. No, that's what I said.